Ag Bioscience, the #1 ag tech podcast globally, is now available on video. Hear from leaders and innovators across food, animal health, plant science, ag tech, and agriculture. Mondays at 6 a.m. on YouTube or wherever you get your podcasts. While you're there, subscribe and leave us a review. It's the Ag Bioscience Podcast with Agronovis Indiana. Get more information at agronovisindiana.com.
The internet changed how we work. AI is changing what work gets done. A bank cut loan processing from days to hours. A student built an AI scheduler, improving on-time delivery from under 70% to over 90%. Most teams know AI matters, but aren't sure where to start. In.AI is Indiana's statewide AI adoption effort, built with industry, academia, and community partners, helping you move from understanding to action. Visit inaiready.com.
Welcome back to the Indiana Lawyer Podcast. I'm your host, Maura Johnson. In today's episode, I'm bringing you a one-on-one conversation with one of this year's Leadership in Law Lifetime Achievement Award honorees, is.Falk. On May 26, legal professionals from around the state gathered in Indianapolis to celebrate their peers during the Indiana Lawyers Annual Leadership in Law event. Each year, we honor a Lifetime Achievement Award recipient, an attorney with at least 25 years of experience whose professional impact extends beyond the courtroom. This year, the Indiana Lawyer honored 2 Lifetime Achievement recipients who've left indelible marks on the profession and in their respective practices. In this episode, I sat down with one of the honorees, is.Falk, to talk about his journey into the legal profession and his career so far. Falk is the legal director of the American Civil Liberties Union of Indiana, a nonprofit and nonpartisan organization defending the civil rights of Klan under the U.S. and Indiana constitutions. Falk joined the ACLU after working for what's now known as Indiana Legal Services. In this episode, Falk shares more about his early career, how his courtroom experiences have shaped him, and what the rule of law means to him in today's legal climate. You can find his full Lifetime Achievement profile on our website at theindianalawyer.com. Let's hop into the episode, but before we do, here's a message from our sponsor.
Taft, today's modern law firm. At Taft, we cultivate a highly respectful, transparent workplace that fosters creativity, teamwork, inclusion, and diversity. We couple our culture with a client-first approach, rewarding lawyers who understand their clients' goals and work to deliver success. Taft, the modern law firm. To learn more, visit taftlaw.com.
Well, thank you so much for joining me. I appreciate it.
My pleasure.
So to start off, can you just explain when you decided you wanted to practice law? What kind of went into that?
When I was in college, I took a semester off and I ended up working in a senior center run by nuns in Washington Heights in northern Manhattan. I went to college and law school in New York City. And at that point, Washington Heights was primarily populated by very old people. It was one of the first subway stops lines that opened up from the Lower East Side. So the neighborhood was changing with influx of others made more famous in the Heights, the Broadway show. But at this point, the center was populated, people coming in who were senior citizens. And they had all sorts of problems. They had income maintenance, food stamps, welfare, housing, consumer. And every single problem, it seemed they had, was something that needed to be remedied by the law. If not a lawyer, at that point, you could go to landlord-tenant court and be assisted by people who were not lawyers, which I did on occasion. But it was really clear that if you were going to try and accomplish something in this regard, you needed to be a lawyer. And my father was a lawyer. My grandfather was a lawyer, completely different type of law than what I do. But I was familiar with the law, and it just seemed like something that I wanted to do. And I decided at that point to go to law school.
Yeah. How did that experience in Washington Heights kind of shape your perception of the law itself and those issues?
Yeah, I mean, I think from very early on, I recognized that there are many segments of society, individuals who are generally deemed to be powerless in that they have no political power. But when you're in court, that doesn't make any difference. You are able to approach courts and approach the law on an equal footing with everyone else. And that was very appealing to me.
Yeah. So obviously your focus in your career has been constitutional law. What was the motivation behind that to pursue that as a study?
I mean, the first 19 years of my career, I was legal services, and I did everything. I did divorces, I did custody cases, I did welfare cases, et cetera, et cetera. And I've always been fascinated by the Bill of Rights and its interplay. And when this job happened to open up in 1996, it seemed like a natural progression because I was doing a large number of larger type class actions of legal services. At that point, Congress had passed a law preventing legal services from doing class actions, from representing prisoners, from doing welfare reform stuff. I'd actually shipped all those cases over to Rich Waples, my predecessor here at the ACLU. Rich said he was leaving. I got his job. I got my cases back. So it was sort of just a natural progression to what I'm doing now.
Yeah, makes sense. And I love something that made me laugh during the leadership in law event was your brief mention of going from New York City to Muncie. And I'm just curious, what that experience was like, and not only just the actual experience in changing cities, but also the experience of practicing law in those two different places.
Well, it's funny because I looked at the article and I don't think I said this. What it said was he had hardly heard of either Muncie or Bloomington because those are the two given to me. I had not heard of Muncie, period.
Yeah.
And I probably heard of Bloomington, but did not know where it was.
Right.
So I came out here and I was told during my interview that if I got the job, I'd go to either the new offices in Bloomington or Muncie. Did I have a preference? I said no, because I didn't. I drove out to Muncie, sight unseen, and it was great. We were opening the office up. The bar had actually sent a telegram to President Carter saying we did not need legal services. So there was a bit of hostility first from some members of the bar, but very quickly they realized that we were performing a service and also realized that generally if there's a lawyer on one side, there's a lawyer on the other side, and that there was this enormous need, family law need. The first day we were open, our waiting room was full of people with family law issues. But it was great. The bar was extremely friendly. I made friends there. There's some people who are always upset about legal services, and I learned how to be a lawyer. I mean, I learned a lot of stuff that you don't learn in law school. I learned about collegiality. I learned about when things could be done informally. I learned about how to resolve problems, try and head things off. And also, I learned how to do class actions and stuff. I hadn't done any of those in law school. There was an enormous amount of litigation that we engaged in. And I met my wife there. I loved my time at Legal Services in Muncie. I left at the beginning of 1980. Yeah, I started 77 and 80 to come down to Legal Services here in Indianapolis, where I stayed till 96. But yeah, I have nothing but fond memories of Muncie. But it was really different. I tell this story sometime, which is that I'm in my apartment, which took me a while to find because I needed to live above the first floor because I was coming from Manhattan during Son of Sam. I wasn't going to sleep on the first floor.
Yep.
In my apartment, it was on the weekend. A nice older woman who I'm sure is much younger than I am now knocked on the door and said, she was, I guess, League of Women Voters, registering people to vote. And she asked, "Are you registered?" I said, "No." Would you like to?" I said, "Sure." And she said, "What party?" And I said, "Well, I'll register." And I was such an East Coaster. I'll register for the same party I was in New York City, which was the Liberal Party. And she looked at me and said, "Honey, we don't have that party out here." And my wife always made fun of me because we went by a cornfield and there was, you don't see this anymore with better pesticides or whatever they use, but there was beans growing in the corn. She said that's where succotash came from. And I thought that's where corn and beans. So she made fun of me, but it was a great experience.
I love that. And I found it interesting what you said about the bar had pushed back on introducing legal services. Can you talk about that more? I'm curious about that.
Again, I know this is just what I've been told. Maybe I saw it, but prior to the office opening up, and it must have been 76, I believe a telegram was sent saying we don't need legal services. In fact, somewhere I have, my sister found it recently because she asked one of my kids if they'd ever seen it. There's an article from the National Law Journal, which used to exist. I don't think it does anymore. They came out to Muncie, and because Muncie was Middletown during the Lind sociological studies, Middletown, USA, Lind speaking in the 20s, profiled Muncie as sort of calling in Middletown average America, and came back periodically. And this was an article called Lawyers in Middletown. And they profiled a number of lawyers, including me, which was interesting because it was like one of these things is not like the other. And I think it's mentioned in that article. I'll look for it and see if I can send it to you because my sister sent it to me because she sent it to my kids. But yeah, the bar was great. And it was, and I've said this, maybe I said this the other day, it was nice being in a small bar. It was, and the collegiality point, you learn very quickly what lawyers were trusted and what lawyers were not. And you learn very quickly how debilitating it is to be a lawyer who is not trusted by other attorneys or by courts, especially in a small setting like that. So it was fun. I knew nothing. I always joke, and it's true. I thought Indiana was on the other side of Mississippi, so I was happy I got here quicker. But I'm happy to be a Hoosier.
Yeah. No, I love that. I guess that's interesting learning about what lawyers were trusted. What was your experience coming to Muncie and building that trust, and also at the same time building the branch of legal services? How did that kind of, I guess, move your career forward?
We were swamped. I mean, we had many, 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 many cases because there was an untapped need. And I could sort the cases into, we filed a class action against the township trustee or against welfare authorities with going to small claims court to deal with an individual landlord-tenant case. It grew my appreciation of the various ways that one could function in this system to achieve some sort of change. And there's one thing I miss about legal services, and I guess probably more than one thing I miss about legal services. It's doing those little cases. It's having a case come in on Tuesday with someone being evicted and being able to work something out on Thursday. Most of my cases aren't like that now. But it was just a question of accruing knowledge. One of the things is, and you don't realize this when you're in law school, you don't know how to be a lawyer. I mean, law schools are doing a much better job now than when I went to law school with practicums and what have you. But there's some basic converting this mass of knowledge you have in your head. It's not as big a mass as you think it is. Converting that to being able to function as a lawyer. I hold some sort of world record about the number of times I went to file a case and forgot all the papers back before there was filing online. You just learn stuff, and it's the best because you're just starting out new. Everything is new. This is what suffered through 3 years of law school, and I did suffer to do. And I've just aside from my family, being husband, parent, grandparent, there's nothing in my life that's been better than being a lawyer. Nothing.
When you were building legal services in Muncie, were there any specific challenges that you faced? I know that you talked about the caseload and the work that, but what else did that look like?
I was hired, the managing attorney who was hired after I was, but was started, I think, by the time shortly after after I was sworn in, had been a lawyer for a year or two. And then we hired another new attorney. We didn't have a whole lot of residuum of knowledge. It was a lot of learning on the fly and doing things. The very first appeal I had was in 1978, I believe. It concerned an Indiana statute that indicated you could not get a marriage license if you owe back child support. And we filed a lawsuit saying that violated the right to marriage and equal protection. And the Supreme Court decided a similar case out of Wisconsin called Zablocki versus Redhale, which made our argument simpler. And so the trial court struck the statute down as unconstitutional. And under Indiana law still now, when a statute struck down as unconstitutional, you go directly to the Supreme Court. So the very first appeal I did was in the Indiana Supreme Court. And I bring this up because a number of years ago, many years ago, I was in the old law library, the old law school. And the Indiana Supreme Court used to bind its briefs. And I was looking right at 1978 or whatever year it was, 79, 78. I thought, wow, I can see the brief, the very first brief. It was horrible. Terrible. It was typed, so that it didn't look great.
Yeah.
Get that. It wasn't a big problem. It was a young person trying to sound like a lawyer. And the very first time I drew up a contract, we used to have form books. And I went to the form book, the first part, second part. I showed the client, and my client said, "What does this mean?" I said, I don't know. So I decided not to do things that way anymore. It's the joke is it's called practicing law, but you really do learn an enormous amount as you start off. And one of the advantages or disadvantages of legal services is that I was thrown into the deep end right away. I learned.
Yeah. How do you feel like that experience at legal services prepared you into moving into your role at the ACLU?
I developed skills. I ended up being the litigation director, so I supervised all the lawyers at then Legal Services Organization of Indiana, but I maintained a full caseload too. So I think it was just a natural progression. In all honesty, I probably wouldn't have left if the law hadn't changed and I wasn't able to do the class actions and the other cases, in addition to the individual cases. But it just seemed like a good time to leave to do something else. And so I've stuck here.
I kind of want to just touch on your mentioning of class action lawsuits. What, I guess, in your words, is the importance of being able to do that in this state and push those cases forward?
Sure. The ability to resolve a problem in one case, one way or the other, because you realize that, when you have a class action, if you lose, then everyone else is bound by that. If it's an injunction class called a B2 class, the ability to do that is I think very impressive and necessary given our limited resources. It's also necessary sometimes because of the nature of the case. There are doctrines under class action law that allow the case to continue even after the named plaintiff is no longer affected. You couldn't do a county jail case, for instance, that's going to last 2-3 years with an individual who is released 2 weeks after you file the case, unless there were those doctrines. So it's a effective way from a standpoint of everyone's time and the court's time as well to resolve a problem.
Makes sense. Now moving into just your role with the ACLU, I guess what were those first maybe couple of years like for you in that role? What kind of challenges were you facing, kind of triumphs?
Sure. I mean, when I first started, shortly after right when I started, I was the only attorney, and I was that way. Oh boy, time. I was that way for a couple of years. So trying to figure out, I walked into an appeal in the Seventh Circuit, a First Amendment appeal, the Establishment Clause. I had dabbled in the Constitution, but I didn't know the Establishment Clause. So, there was a learning curve there. It's just what I do. I don't, and when people ask me that question that you asked about triumphs and stuff, I just don't. I've done an enormous number of cases. I've lost an enormous amount of cases. I tend to remember cases I've lost because of the clients being hurt. I've done some cases that really are very sad because I felt that I could have made a difference in the client's lives and the law was not with me. And that's the way it works. I accept that. But I don't think about successes and failures that way. I think the process is what's important. The ability that we're here to do it is what's important.
Right. Well, and something that stuck out to me at the event and then also in your profile was you talking about how many cases the ACLU gets daily, weekly. So I'm curious about that process and how you pare down and figure out what cases to take. And do you ever have to consider, I guess, the ACLU's position in society when taking over those cases, obviously with its prominence and just what it stands for?
No, I mean, as far as litigation is concerned, as I've said repeatedly, we exist to represent people whose constitutional rights are violated. I have represented the KKK. I have represented the NAACP. I have represented abortion opponents. I have represented a lot, Planned Parenthood. I've represented police officers. I've represented prison. You name it. I've represented them because we don't focus on who the client is. We focus on what I shouldn't say that. We obviously focus on, we are client centered, and that's not perception centered. We are, if a client has a constitutional problem, we look at the problem and see if we can resolve it. As simple as that. So that's never a consideration.
When looking at these cases, is there a checklist that you have to go through to determine what cases you can take on? What does that process look like for your team?
When we take a case, the idea is that this is a problem that hopefully, if we resolve it in the client's favor, it will have a ripple effect. Frequently, that means we're filing for injunctions to stop a law from going into effect, to stop a practice. However, we also sometimes file damages cases. And the damages cases are basically cases that, for whatever reason, private attorneys will not take. I mentioned, I don't know if I mentioned this. We recently settled 31 cases out of Miami Correctional Facility for 31 separate prisoners who were placed into a unit where the windows had been broken out by other prisoners and had been covered with metal. The lights broken out and the lights were not working. Sometimes there were live wires hanging down. The window, the little slit window in the door sometimes were broken as well. These people were put in the dark, sometimes for weeks or even months at a time. Some of them were shocked because they would try, their food is slid through a slit in the door that's open for that purpose. To get there, they had to navigate the cell. They got shocked. They bounced into things. Prisoners were displeased by their living conditions, would flood the unit with sewage. It was horrible. No private attorney is going to take that case because of limitations imposed by the law under something called the Prison Litigation Reform Act on things like attorney's fees and what have you. And so we took them as damages. We settled for about $1.2 million for the prisoners. We did that not because we're constitutional tort attorneys, but because we thought it was necessary to make the point that this should never, ever, ever happen again. Yeah. So that's a consideration in cases as well. We tend to have a lot of cases because we tend to work a lot.
Yeah. I know that you mentioned a few minutes ago and also during the fireside chat, this concept of you don't win every case. And so I'm just curious, how do you, pick up those losses and move forward with the hope that you're going to succeed in the next case or
Sure.
win the case?
Because I have deep down innate trust in the American judicial system. If a court says no, and if the appellate court says no, if I'm at the end of the line as far as concerned, then it's over. I move on. I talk to my client. I console my client. My clients generally, as I think I mentioned many times, they would rather win, but they always appreciate having been listened to. Most of my clients and the cases we file are for people who simply don't have a voice, and they appreciate the system. So it's not a question of going to a dark room and ruminating and then coming out and saying, I'm ready for the next case. It's just the process. And as a lawyer, you have to buy into that process. They're not lawyers who win. Maybe there are lawyers in every case, but I'm not one of them. And I don't expect to. And especially since we take cases, one of the great things about the law I do is that every lawyer, when a case comes in, plaintiff's case comes in, has to sit down in their own mind and say, what are the chances of winning? And what does that mean? There's a bottom line, which is Rule 11. You never go to frivolousness. But above Rule 11, there's a great space. Do I take this 35, 40% case and turn down an 80% case? Do I take this case where I'm going to have to depend on attorney's fees if I win, as opposed to a case where I'm going to be paid? The great thing about the work we do is we don't have to think that way. I have won cases that I put in the low end. On the other hand, I've lost cases I put in the high end. But that sort of analysis doesn't play in at all because we push the law. Some people talk of the law, the law as a shield, which it is. But in many ways, it's a sword, and we push forward. And sometimes we win, sometimes we lose. But that's the process. That's how the common law evolves.
Yeah. Looking back on your career so far, is there any case or...
Well, the so far part, because I hope that after a Lifetime Achievement Award, the next one is posthumous.
But just looking at your career, is there a case that really sticks out to you, and maybe, I don't know, in any way, and the challenges you faced, or maybe the client in particular? Is there anything that sticks out?
There are many cases that I have felt emotionally very strongly tied, not emotionally tied to the client in a proper way, but the case that the transgender care for kids, the case still is alive, but that the Seventh Circuit reversed a preliminary injunction on, the Supreme Court in the Scrimeti case said no equal protection challenge. I sat in a deposition where one of our clients said that after the child began to receive hormones, they received their child back. And I have heard from clients similar things, hearing from prisoners about what it's like to be locked in a cell where they but they have to trudge through sewage in the dark, risking getting shot to get food. That sticks with you and makes you want to fight for those clients. Yeah, that's what sticks with me. Although I did have this. The first time I argued a case in the Seventh Circuit, I was extremely young. I skipped a couple grades going through school, so I was numerically young. But more importantly, I was very young as a lawyer. I was in 1979, and I was terrified. I was just so terrified. I wasn't aspiring to do well. I was aspiring to survive, and when I survived, I never really had become nervous. But the first time I argued in the Supreme Court, and I don't know if you've been in the U.S. Supreme Court, but you're very close to the bench, and you're sort of in a V-shaped long table where the podium is looking right at the Chief Justice.
Yeah.
And you go in and you sit down, and it gets very quiet, and there's a gong that goes off, and the curtains part, and the justices come. 3 come to the left, 3 come to the right, and 3 in the Chief Justice. And I looked up, and I thought, and I wasn't nervous. I was just another case. I knew it really well, and it was fun. Oral argument is fun. People don't realize how much fun it is to be able to just go 1-on-1 or 1-on-9 or whatever it is with a judge. But I thought for a second, God, that guy looks like the Chief Justice. And I went, whoa. That was fun.
I love that. I don't know how you're brave enough to stand in front of them. I couldn't be, but I love
it. People think it's so nerve-wracking, but you prepare like anything else. If you prepare, and you prepare really well, and you know the case really well. But the fun part about oral argument is that in any case you have, there are always weak parts. And when you have oral argument before good judges, and my arguments are always before good judges, they don't go to the strong parts of your case. They know that. They want to hear going to the dentist without a Novocaine. They go right to the weak part. So being able to prepare for that's fun.
Yeah, I love that. What advice, if you could give one piece of advice to younger attorneys starting out and navigating this practice of law, what advice would you have for them?
When I would teach, I would, at the very first day of class, I would say, look, I want you guys to take out paper back in the day on the computer. I want you to pretend that we are in a society just like ours, exactly like ours in terms of advancement and what have you, but there's no jobs. I want you to tell me the 6 or 8 jobs that you have to have. You have to have. And they'd come up, and half the class would always say lawyers, but they'd leave out plumbers. And I'd say, look, the purpose of the exercise is not to say that lawyers aren't important. Lawyers are vitally important given our way society is concerned. But the important part of this exercise is for you not to be arrogant about being a lawyer, because you're no better than a plumber. You are given a task to do, you do it. You have special knowledge, but as my wife could tell you, knowledge in law does not transfer to knowledge in plumbing. And so don't be arrogant. Appreciate your clients, appreciate how important your role is in society, but have some humility, have humor, understand how important we are. At the same time, as my exercise indicates, we could do without maybe, but we can't because of the way we're set up. We're vitally important. And your most important task, whatever you end up doing as a lawyer, whether you're doing corporate law, plaintiff, defendant, prosecutor, whatever, is to strengthen the system. Because without this system, without the respect, without the knowledge that you bring, and without doing things the right way, you degrade the system. And that hurts everyone. And I feel really, really strongly about that, which is why I think I have said for years, I don't want to hear any of you ever criticizing a judge. You can criticize an opinion. You can say you think the logic is wrong. But the idea that somehow you think a judge has done something wrong because you've lost, number one, you articulate that and people who aren't lawyers hear it and they think it's okay to criticize judges that way. And number two, you're going to lose. That's how the system works. Judges bring different perspectives and that influences what they do. Judges try and do the best they can. And sometimes you're wrong. I have filed cases where the court decides a case. I say, okay, I was wrong. So I think all that kind of rolls into respect for the law. I would tell young lawyers that this is a fantastic profession. It's an honorable profession. It's a profession that needs to be protected. And as I said during my fireside chat without a fire, it's under attack in a very dangerous way that should not be countenanced by anyone, regardless of their political persuasion.
Yeah. Well, and bouncing off of that, obviously in the last few years, there's been a lot of discussion about the rule of law and kind of where it sits in the legal profession and then widely in the country. I guess, what is, from your perspective, what does the rule of law mean to you, and what does the legal profession need to do to uphold the standards that they're given?
Yeah. Well, as I've said repeatedly, judges don't have armies. Judges don't have the ability to do things to enforce their decrees. Of course they can, with contempt or what have you. But ultimately, if society decides we don't have to listen to judges, we don't have to follow the rule of law, then it disappears. And so what has to be done is to shore up in every possible way the respect we have for the process that we have for development of the law. I mean, that respect is not just for judges. It's respect for the Bill of Rights. We have entered a time in society where First Amendment rights are fine as long as I have them, but not if you have them. And that cuts across the political spectrum. I am neutral when it comes to my concern when I see groups shouting down people, when I see general disrespect. It is poisonous. I tell this story, and it always embarrasses my older son. Years ago, we did a number of cases concerning drug testing of student athletes before the Supreme Court decided the issue. US Supreme Court, not our case, but we were talking at the dinner table. My wife and I have two boys, and my younger one was elementary, and maybe early middle school. Then Josh, my older, was maybe sophomore high school, and we were talking about drug testing, typical dinner conversation. And my older son said, perfectly valid, said, I don't care. I don't do any drugs. What do I care? And my younger son said, yuck, that's yucky. So I changed the will for the younger son because I liked his answer better. But the point is that if everyone adopted the attitude of my older son, which we ended up adopting because of the US Supreme Court, that right goes away. I mean, remember after 9/11, we were all asked to sacrifice some of our rights to Fourth Amendment rights, and which was no skin off my teeth, although some Muslims I know didn't fare so well. But when society, the Bill of Rights is so ephemeral that if we all decide somehow not to fight something, that's the end of it. And so it's really important to me that people respond to threats on their rights, which is why we don't discriminate against who we represent in that regard. I've done cases if the KKK is not allowed to march with masks on, which was a case we did out of Goshen, one of the nicest communities in the state, in terms of people being friendly and what have you. And perfectly understandable why they didn't want the Klan to be there with masks on. But if we allow that, then what about the environmental protester who wants to protest air quality by wearing gas masks? What about the political protester who want to wear a picture of President Obama while they protest his policies? It all goes away.
That's really interesting. Well, thank you for this conversation. I enjoyed it. I hope you did too. And I love your wisdom and enjoyed it. And your insight, loved it all. So thank you so much for
talk to my kids about my wisdom, okay?
Thank you for listening to the Indiana Lawyer Podcast. To hear more from Falk about his career and work at the ACLU, you can actually go back a couple of episodes in our podcast feed and find his conversation with fellow Lifetime Achievement honoree Jim Bopp during this year's Leadership in Law event. And if you're not already subscribed to the Indiana Lawyer, we encourage you to do so. You can find more information on that on our website at theindianalawyer.com. Subscribers always have access to the latest legal news in Indiana and stories from our sibling publications, the Indianapolis Business Journal and Inside Indiana Business. Tune into our next episode on July 8th, where I sit down with our other Lifetime Achievement Award honoree, Jim Bopp, principal attorney for the Bopp Law Firm.